Please be seated. We welcome you to the last case of the afternoon, and we appreciate your patience. We appreciate your willingness to travel to Lubbock to present oral arguments. I wish there were, given the quality of the litigation, the attorneys that we've had today, this is no exception. I wish we had more students in the audience to see you guys in action. I think they could learn from it. But we don't, and we'll proceed anyway. The last case we have is 07-21-003-315-CV. In the state of Texas, Jerry Patterson, former commissioner of the General Land Commissioner Land Office of the state of Texas, and Commissioner George P. Bush, Relators. A mouthful. Mr. Osborne, you're the relator. Are you ready to go? I am, Your Honor. Thank you. And Mr. Sheets, you're going to be presenting argument for real parties and interest?
Yes, Your Honor.
Is it just you? You're splitting time?
No, it's just me. I'm going to take it all.
Okay. And will both counsels introduce co-counsel that's sitting with them, please? Thank you.
Bill Warren with Kelly Hart Hall.
Thank you. And with that, Mr. Osborne, you have the floor. Even with that microphone, sometimes we have trouble hearing. So
right, I'm going to try it over here. Is that good? If it's not, I'll be happy to move it.
And make believe you're on a Broadway stage and project.
All right. May it please the court, counsel. I'm Mark Osborne, and I'm here today representing the relators, who I will refer to in this mandamus action as the defendants. This is a disqualification case involving Joseph Austin, an attorney who represented the defendants in this very case back in 2017, excuse me, and who subsequently has moved to Fort Worth and has now begun working at Kelly Hart, one of the firms that is representing the real parties in interest that I'll refer to as the plaintiffs. These disqualification cases are very difficult. I know that because I've been on the opposite side. My experience is that in these types of cases, the law is bad, the facts are bad, the outcomes are bad, no matter who wins. I would rather really be doing anything other than appearing before you in this case today. Kelly Hart is a very good firm, very good lawyers who finds itself in a difficult situation. I spent 15 years having the honor of serving on the Texas Supreme Court's Professional Ethics Committee, including 5 of those years as the chair of that committee. During that time, my experience was that disqualification cases arising from conflicts of interest were the single most difficult issues we had to address. But we're here as lawyers today because 2 of our most important values are protecting clients' confidences and preserving our clients' expectations of loyalty. Rule 109 of the Texas Disciplinary Rules of Professional Conduct provides that a lawyer is prohibited from representing a party if that lawyer has previously represented the opposing party in the same case.
Can I stop you right there? Can you hear up there? Thank you.
Okay. And it also provides that a lawyer is prohibited from representing a party in a case if that representation creates a genuine risk of the disclosure of client confidences of a former client. And the rule finally provides that in both of those situations, if the lawyer is disqualified, then all of the other lawyers at that lawyer's firm are also disqualified.
Mr. Osborne, let me kind of stop you there and just
Yes, sir.
ask you a question about the phrase genuine risk. With respect to this matter, briefing indicates that we're talking about a baby lawyer, less than a year's experience, bills 1 hour. I think it was for reviewing a case. Was it reviewing files or receiving confidences or communicating with clients? but reviewing some case, and that's it. Out of some 4,000 plus hours of billing, what is the genuine risk of client confidence being compromised in a situation?
If I may correct you about what's in the record, Your Honor.
Okay.
The record, what the time records actually show is that the defendant not only did that, but Mr. Austin not only did that, but he also was in communication with the defendants. He talked to the client back and forth about the work he was doing. That's in the time records. They're redacted records, but that's in there as well. In addition, the evidence in the record is that Mr. Slavin, who was his supervising partner and mentor, had several discussions with him about the case, including disclosing to him the strategies and the defenses of the defendants in the case. And the reason he did that is because it's the same way I work. That's how we work with our young lawyers. We tell them about the cases we're working them on. We get them involved so that they not only, even if he had not done any work in this case, literally if he had not billed that hour, he knew about the client confidences. It's just like the Henderson versus Floyd case, where he had learned about it from meetings with lawyers in the firm. Now, to answer your question, I can't tell you. The reason I can't tell you is because I can't reveal the confidences. If I were to do that, I would defeat the whole purpose of these kind of actions, which is not to reveal the confidences in order to protect them.
Can you not reveal the confidences? We have
No.
in-camera hearings all the time where the judge is allowed to consider in-camera confidential information
No.
in order to make a determination.
In these
What law
just-
says you cannot ask the judge to do that?
All of these cases, and there are 5 different ones in front of the Texas Supreme Court on essentially these facts, not the waiver issue, but essentially these facts about a former lawyer. There are 2 irrebuttable presumptions. The first irrebuttable presumption is that the lawyer, if he works on it, it doesn't matter how much, or if he learned about the case, he has confidential information of the client. That's an irrebuttable presumption. The second is that every lawyer in his new law firm has access to that confidential information of the former client. And then those cases go on to say that the courts will not require the revelation of that confidential information, because that's the whole purpose of the disciplinary rules, is to protect the client's confidences. And where you see that they don't require it is in most disqualification cases, there is a requirement that the law has actually evolved. The initial requirement was that the party moving for disqualification show prejudice. Then the Supreme Court action, it's over a series of cases, but eventually evolved to say that in most of those cases, both sides have to show their prejudice, and the courts will balance that prejudice.
Certainly the most recent opinions from the Supreme Court
absolutely
look at prejudice to both sides, right?
Yes, except in Rule 109 and actually also Rule 106, which is the current client rule, but they're essentially the same in this purpose. In Rule 109 disclosures, you do not have to show prejudice, and you don't look at the non-moving party's prejudice to balance them because you can't.
Maybe I missed something. What's your authority for you ordinarily have to prove prejudice, but you don't when you've got a Rule 109 case? Has the Supreme Court ruled on that?
Yes, Your Honor. If you look at cases, and I will tell you, there's no case that has literally said that,
Right.
made that analysis. But if you look at the cases that do not involve either 109 or 106 disqualifications, the Supreme Court has evolved to the place where they are now saying you must show prejudice, each side, and we'll balance it. That's clear. But when you go back and look at the Rule 109 cases, and it begins with Henderson versus Floyd, the court said, we are not going to require you to show prejudice. And if you look at every 109 case, the courts have never said, we're going to make you disclose the confidences in order to show the prejudice. So that exception is there. The court has never come out and literally addressed this question, but that's what the cases teach. And so to answer your question, Your Honor, I cannot disclose those to you. I will not do it. If we had to lose this case to not do it, I'm going to protect my clients' confidences. And the law is that the courts may not require us to disclose it, whether it's in camera or not. So we go back to, with that being.
So Mike,
Yes.
is it your position that the disqualification was mandatory? There was no discretion that the trial court could have taken into account at all?
Let's assume that I'm going to set aside the issue of waiver.
Sure.
But if in the absence of a waiver being raised or something else that didn't come up in this case, there is no discretion. This is a case that requires disqualification. And if you look at the Supreme Court cases, Henderson versus Floyd, and there's several others after that, on 109, I agree that the cases generally teach the disciplinary rules are guidance.
Right.
And the courts
So
have
I guess that's what I'm
discretion.
trying to say.
Yes.
109 sounds mandatory in nature, but the Supreme Court subsequently said, but 109 is guidance.
Well,
It seems to suggest the trial court can take other factors into account.
let me tell you why I think it differs and depending on the rules you're talking about. It is generally true, and across the board it applies, that the disciplinary rules are used as guidance by the court. They don't dictate results, and that's appropriate because disciplinary rules are actually when you have violated a rule, and the purpose for them is to do things like grievances and things and to punish lawyers, to correct behavior. Disqualification is an entirely different issue really in a court, and the issue is what's the right remedy to solve the disqualification. It's not whether we're going to punish a lawyer or not for violating the rule. So you have that general concept that they're guidance, and the courts do follow them, but they don't have to strictly follow them. They're not mandatory. Where that exception comes in is in the disqualification cases on 109 and 106. The courts continue to say that, but then you will see they also say where you have a lawyer who's represented a former client in the same case, disqualification is mandatory. Or if you had it, where these cases normally come up is it's not the same case, it's a substantially related case. Once they determine that it's substantially related, you will not find a case that says, but we're not going to disqualify. Setting aside issues like waiver. But if we're just looking at those facts, the disqualification is in fact always mandatory. The reason it's not in the other rules is because you have other options to fashion remedies with other rules. The examples are, if you had a case that involves disqualification where someone's improperly obtained some privilege information.
Sure. Chinese wall, right.
You have other remedies that you can look at so you don't have to disqualify. In the Rule 109 and 106 cases, there are no other remedies. I wish there were. I'll tell you as a practicing lawyer, I wish the Texas Supreme Court would say we could screen lawyers. It's a very difficult burden for us who practice in law firms and trying to hire lawyers not to be able to do that. We can screen with non-lawyer staff. If I had that remedy, I think the court could say, I'm going to screen and allow that, but here, the Supreme Court says we're not allowing that, so it's either yes or no.
Your legal position, though, is when you have an attorney who goes from one client to another client and those two parties are still fighting in litigation, one, irrebuttable presumption that the communications are being sent over. Two, irrebuttable presumption of prejudice. And three, mandatory disqualification, right?
Yes, that's in essence it.
Okay.
Yep.
Where is the fear of disclosing confidences in Mr. Slavin pretty much inviting Mr. Austin to go work for a competing firm?
Okay, I will.
Didn't Mr. Slavin know that Mr. Austin had confidences?
I will tell you what the testimony.
Yes or no? Did Mr. Slavin know that
Yes.
Mr. Austin had confidences?
Yes.
Mr. Austin, a young attorney, went to his supervising lawyer and said, what do you think? I've got this opportunity. What do you think? And the supervising lawyer, knowing that he had confidence, says, yeah, go on and work for that firm. Sits back. I'm assuming he smiled. And then once he went to work for the firm, he says, now I can disqualify your firm.
Your Honor, that's not quite an accurate reading of the events in the order of what happened.
That
Let
is
me
not
address
what
that.
the email says?
No, let me address it.
Yes, sir.
There was a first on March 16th, what Mr. Austin Mr. Austin initiated the communication, and it's with a friend. They're friends. We're friends to this day, Mr. Austin and I. The first communication, and this is all by text, Mr. Austin says to Mr. Slavin, I'm thinking about talking to Kelly Hart. The truth is he had actually gotten farther by that point, but that's what he said. And Mr. Slavin said, good firm, big money, go for it, okay? Mr. Slavin testified at the trial hearing that when that first communication occurred, it did not occur to him on that communication about the conflict. He did not think about it.
Do we have to give weight to that testimony? As
No.
a part of our standard of review,
No.
we
I
could
think
say,
that-
we could assume the trial court disregarded that.
Yes, I don't think that testimony is actually relevant to the issue of waiver, and I'll explain why, but I want to answer your question first, Your Honor. The second communication was on March 30th. That March 30th communication is the one, and he started work on April 5th, so it's several days before Mr. Austin starts to work. He's got an offer, he's accepted, but he hasn't started. Mr. Slavin says, great, now I can disqualify Kelly Hart, something to that effect. That may not be the exact quote, but that's the essence
But
of it.
then he's accepted the Kelly Hart offer?
He had accepted, but he had not started.
Okay, he's
Okay.
accepted the offer, so there's a
Yes.
contract in existence between him
No,
and Kelly.
well, if you want to talk about employment, this is employment at will. He would not have breached any contract to called up and said, hey, I can't go to work there. That wouldn't have done a breach of contract or anything. You can do that the day
So
before
was
you
he still
start.
working for your firm at the time?
No, he actually moved to Fort Worth and worked for a different firm in the middle and then went from that firm to Kelly Hart. Okay, so let's get to that communication though. Objectively, when you read that communication, Mr. Slavin testified that he meant that as a humorous way of raising the conflict. I will give you, I think in retrospect, I think Mr. Slavin agreed he should have said it in a different way. That was his testimony. And to answer your question, Your Honor, I don't think the trial court has to accept that.
Could a reasonable trial judge have looked at Mr. Slavin's text and said, this is a game of gotcha?
No. Here's
Why
the
not?
reason why, Your Honor. Because objectively, look at the words that he used. Objectively, what he did was he warned Mr. Austin about the potential conflict if you start. That was a warning if you read the words. It doesn't matter what his subjective intent was. You could believe Mr. Slavin that he was trying to say it humorously. You could ascribe a different meaning to it, which the real parties in interest do.
If he had already begun employment, or let's
He
say
had
this,
not begun
if he had already
employment.
accepted the job,
Yes.
it
would
was
be
a
different-
conflict he couldn't fix at that point, right?
That's right. It would be a different situation there, but here it's a warning. Let me give you a horrible analogy,
But this woman came after he accepted the offer.
but before he started.
But
Yes.
after he accepted the offer.
That's correct. But the conflict did not arise until
So
the
when do you
day he
start-
went to work,
When does employment start? At the time?
April 5th, when he goes to work, when he shows up in the morning.
When he goes to work, not when he
Yes.
accepts the agreement, the
That's
offer?
exactly right, Your Honor. If I accepted a position as a staff attorney on your clerk and said, I'm going to start in a month, I don't become an employee till I go there and I start. There is no conflict until
Well,
he starts. to
apparently,
work.
Mr. Slavin thought that would warrant accepting the offer was enough to warrant disqualification,
No.
even though he hadn't employed, because he hadn't started employment when he said, well, now I can disqualify that firm.
I think that's why I'm saying when you read it, that was actually a warning. He did not think he could disqualify him now. He knew he wouldn't be able to disqualify him until he started work. That's
we're-
why you have to read
But
it
that's
as a
not what
warning.
Mr. Slavin said. I don't think I can disqualify you. He said, now I can disqualify you.
Right, but that's not true, so it had to have been humorous, although I don't think you have to get to that interpretation. Let me give you the example where I hate this example, but I think it's halfway decent. I'm the quarterback, and I'm calling a play, and my intent is to deceive the defense. So before I start the signals, I yell to the defense. Now, the play I'm going to call is a screen pass. And I yell out to the defense, this is going to be, and in my mind, I mean to say a draw. So I'm going to be deceptive. But what I actually say, I get confused and say, this is going to be a screen pass. And it actually is a screen pass. I may have intended to be deceptive, but I wasn't, in fact. The objective fact is, I wasn't deceptive. I was actually telling them what I'm going to do. Here, the objective language, given the timing of the events, was a warning.
In the arena of mandamus,
Yes.
and that's what this is, we're told historically, unless the Supreme Court changes its mind again, that it's an equitable writ. It's equitable as opposed to legal. To what extent can you consider principles of equity such as unclean hands and, well, I don't want to say misconduct, but unclean hands where you helped invite the circumstance which you now complain about?
I think you have to still consider them within the context of what the cases have said is the law. The issue here is waiver. And there are 5 factors the courts look at in determining waiver. The relevant factor to
Did
this.
any of those cases say you cannot consider other equitable principles, that you're limited only to waiver?
No, Your Honor. But I believe if you read Henderson versus Floyd, it teaches that. Because it looks at other things that could have happened in Henderson versus Floyd, and it's very similar.
Did Henderson Floyd involve a situation similar to this where it could be read that the party that's claiming wrong helped create the circumstance that they're complaining about?
Okay. The answer to your question is no, but my position is the communications here did not give rise to the conflict. They may have not been stated in the best way possible, but this is not a situation where someone, let me give you the example that I think would be the opposite. If Mr. Slavin had initially called Mr. Austin and said, hey, I think you ought to contact Kelly Hart and try to go to work for them, I think that could lead to saying we're using the motion as a dilatory tactic. And that gives rise to waiver. That's within the confines of the law. That is not what happened here. Objectively, Mr. Austin and Kelly Hart started it all. Objectively, the only thing happened is that Mr. Slavin gave him a warning 4 or 5 days before he started work.
But to be clear, from our perspective, from the standard of review that we have,
Yes.
and from the guidelines that we have in assessing the evidence and the testimony, we have to construe Mr. Slavin's testimony in a light most favorable to the other side, do we not?
No. Here's the reason why. I don't think there's any construction due. I don't think there's a fact dispute on this. You have to look at the objective language. It doesn't matter what his intent was.
But no, there's certainly a question about what Mr. Slavin meant from his words, from his text message.
No, here's my point. There can be certainly a factual dispute about the intent, but intent doesn't matter. Where this fits into the waiver context is it being used as a dilatory tactic? That's the legal framework where you decide. It's not relevant what his intent is to whether it was being used as a dilatory tactic. It's just like my example. I may have intended to deceive if I'm the quarterback, but I failed because I didn't give the right message. Here the question is, was it being used as a dilatory tactic? In fact, because it was a warning, it was not being used as a dilatory tactic.
Counsel, your time's expired.
Yes, Your Honor.
No.
Thank you, counsel.
May it please the court, counsel.
Mr. Sheets, you're going to need to speak up. Make sure you project, please.
Yes, I'm trying to position myself. Is that better?
I can hear. Can you guys? There you go.
It's an honor to be in front of this court again. It's been some time. The argument of Mr. Osborne makes me sad. He is talking about these communications. And instead of talking generally about them, and there are just a few, I'm going to read directly from the record as to what those communications were. April 5th is my first day. Too good of an opportunity to pass it up. Mr. Slavin, try to work for someone other than Warren if you can. I will thank you. You can thank me later. Warren knows Osborne. Mr. Slavin, now he does. I have Mark on my Canadian River team. Glad you will be there. now I can disqualify Warren. There's no way to take that language on its face other than the obvious conclusion that he is telling this baby lawyer that now he has accomplished what he intended to by using this young man as a pawn in a sinister game to get rid of this law firm that had logged 4,000 hours in this case. Now, if one were to say, well, should we discuss what was meant by that? If you initiate a discussion of what's wrong with that or what was intended by that, you get into facts, which in the position of this proceeding, this court can't substitute the fact determinations of the trial judge. And either this is totally reprehensible conduct for a so-called mentor to a baby lawyer. It's either that and they lose on the harm and the damage to the profession that brings, or you have to talk about facts.
Well, opposing counsel is arguing that what you just read occurred before the initiation of employment, even though it was after the acceptance of the offer.
Yes.
So that still gave Mr. Austin an opportunity to step away and avoid all this problem. But he didn't. He went forward.
Well, that's what happened. Yes, Your Honor. And part of the cynical nature of the whole thing is this law firm and its experienced lawyers put all the heat on this young lawyer to do the right thing, if that's what they're telling him. They put it on him, not them, to pick up the phone and say, look, Mr. Warren or whomever at Kelly Hart, this is going on, and surely, we don't want this to happen as far as his employment.
Doesn't that cut against you, though? Because if we're weighing equities of what one big firm could do versus what the other big firm could do, it seems to me that Kelly Hart would have been in the best position of anybody to say, hey, we've got a new kid coming into our firm. He's given us his resume. Let's look and see if we have any conflicts before we tell him to start.
Right. And the people at Kelly Hart did talk to both Osborne and to Slavin, and no point was raised about any concern on the part of Kemp Smith. So
You mean prior to employment, they were consulted as...
They talked generally about him coming over, but they didn't ask the question, do you have any problem with this guy coming by or starting with us or anything else, did they?
Well,
I mean, firms do this all the time. There are provisions all the time to check conflicts for incoming lawyers.
understandable, yes, Your Honor.
That seems to have fallen through the cracks here.
Well, we don't view it that way. And again, we are weighing equities on each side here. And what has been talked about almost exclusively by Mr. Osborne so far is this question of dilatory tactics. And there are other considerations in that analysis. And if you take, from the brief of the state, they set out, there are four criteria, four categories there of concerns. They state on page 5 of their reply, in deciding whether a party moving for disqualification is waived, it has a right to do so. Courts consider the length of time between the conflict being known and the motion being filed, the moving party's explanation for the delay, and whether significant discovery has occurred, and whether it's a dilatory tactic and whether delay has prejudiced the other party. And we believe the record shows that there's extreme prejudice against the disqualification, and that the trial judge here did not have to believe Mr. Slavin's testimony. And Mr. Slavin's testimony at the hearing in the record, with regard to all of this supposed constant talk about this River case rather than any of their other business, what Mr. Slavin testified to was, although I do not have a specific recollection of the discussions of this nature that I had with Mr. Austin regarding the lawsuit, because it is my practice to do so in connection with working, training, and mentoring Mr. Austin during the time he worked for Kemp Smith. He would not even say on the stand under oath that he remembered.
Let's say that he had remembered. He couldn't have testified about it anyway, could he?
He could have answered the question positively that it had occurred, and then there would have been a fight at the moment as to whether he could talk about it or not in the hearing, Your Honor.
I asked a question a while ago about some of the newer cases from the Texas Supreme Court dealing with both sides now presenting evidence of prejudice. And my understanding of I think I was the one who characterized it. If my characterization of the relator's position was correct, it is there was an irrebuttable presumption of prejudice on one side versus evidence on your side. Are you in agreement with that, or are you in disagreement with the relator?
No, I'm not in agreement at all with Mr. Osborne's view.
Well, what do we do with cases like Henderson against Floyd?
Well, first of all, I'd point out that Henderson was decided in 1995, and there's been a good bit of jurisprudence since then. And it's our view that the more recent cases hold that no matter which road Kemp Smith tries to go down, they come into waiver. Waiver is there in the jurisprudence of this issue, regardless of which path they try to go down.
What do we do with Henderson, though, under those circumstances? I don't think we could ignore it. I understand you're saying that there are more recent cases, but how do we resolve the apparent conflict between the opinions?
Your Honor, we don't have any problem with going with the multi-pronged analysis set out by Kemp Smith on page 5 of their response. And those are the items that I repeated a few moments ago. And something that's totally been ignored, and I would if I were them, is this case, this fact pattern, has to set the outer limit of the effect of prejudice of a motion to disqualify. This case was filed by the state in 1993. And Mr. Osborne mentions in his brief that there's been very little discovery. Well, he's the new kid on the block. They came on in 2013, and he makes the peculiar statement that unless the experts have been deposed, you haven't had any discovery, which makes no sense. There's been enormous discovery. There's 4,000 hours of time on the part of Kelly Hart, and that has to set. I don't think you'll find a case in the English-speaking world with more prejudice to the one against whom a motion like this is filed.
So your position, basically, they still have to show prejudice under the disciplinary rule, or the disqualification rule.
The prejudice to the landowners in this case. For losing counsel, yes.
So prejudice is still a factor, an element.
Right. But
It's
waiver.
just not application of the disciplinary rule.
Right. And the disciplinary rules, the cases say, and counsel admitted that those are suggestions and recommendations. And somehow, counsel seemed to indicate that something in his experience for which he did not give a case has made that carved in stone and irrevocable. And we can't find a case in any of the briefing in this case that supports that proposition.
Have there been cases that have used the disqualification rule to say you're disqualified? They rely on the rule itself to say you're disqualified.
Yes, cases have said that.
Isn't that indication that even though they may be some may be guidelines, there are also rules that have to be followed?
I think what that means, Your Honor, is that a trial judge can on his own give that extra authority than the jurisprudence necessarily does, and he can make that his own rule in his trial, and then it can be tested on appeal.
Do you remember if in Henderson, the trial judge had initially ruled that that firm was disqualified? It seems like if deference to the trial court is an issue we're looking at, then maybe that determines the outcome of what the appellate court does. Or did the appellate court say, I don't care what that trial judge did, you abused your discretion, we're going to disqualify the firm anyway?
Well, I think they would have to articulate that in a way that it could be helpful to somebody like me down the road, trying to look at it. But what we're saying is...
I guess in Henderson, what did the trial court disqualify the attorney? Do you recall that?
I do not, because what I did, Your Honor, is I took the more recent cases, and that's what we tended to put in our briefing. And the court can tell from looking at the briefing that they were done by more articulate lawyers than I, because I've been here before. But the approach was to try to get what the extant law is, and we thought we put that in our briefing, Your Honor.
In the cases, the more recent cases you cited, do you recall whether some, all, or none of them involved a situation where the trial court actually disqualified the court or the attorney?
I think, without trying to pick one, and I could have picked one some time ago better than today, but what I'm saying is that there is no case cited in the briefing by either side where a finding of waiver by the trial judge has been overturned in these type of cases.
So you're implying that there have been cases where the trial judge refused to disqualify because it found waiver?
Yes.
Okay.
And we think that waiver is a roadblock that the state of Texas hits any road it takes to try to get rid of the Kelly Hart law firm.
Is it just waiver, or given that this is a mandamus setting, equitable in nature, that we can consider other equitable principles?
I think that you can consider equitable principles because it is an extraordinary remedy. And I think equity, equity is broadly speaking doing the right thing under the circumstances. And I believe on the face of this record, given these texts, without resorting to factual discussions about what this lawyer might have meant when he said grab the money, even though he's talking about going to a firm where he should tell the young lawyer, you better not do that, or whether it's this, now I can disqualify Mr. Warren, that it's my considered opinion that equitable remedies are always available to police reprehensible conduct on the part of a lawyer. Now, if we go back to the argument that was made earlier, we do not see the record in some respects the same way the council does. One we've already pointed out, and that is what Mr. Slavin's testimony had been in the hearing. And keep in mind a number of things that become applicable. One is that the order in this case is a general order. So Judge Brancho didn't say exactly why he did what he did, whether he just chose to disbelieve Mr. Slavin or if he found something else or a combination of other things. So it's incumbent on the state to come in here and disprove every way he could have gone on this record.
Is that the same standard? Obviously, in this case, we don't have findings of fact and conclusions of law because we don't have a bench trial. We don't have a final judgment. Is the standard the same?
Your Honor,
when you don't have findings and conclusions? Or when it's impossible to get findings and conclusions, I guess is what I should say.
Here's the way I think about it, and it may or may not answer your question. I consider it like the granting of a motion for summary judgment without saying why you did it, where the judge just says, I grant X's motion for summary judgment. Then if it's granted against me, I've got to come in and disprove every way possible that he could have based it on. That's the analysis that works for me, and I don't know if it's correct or not.
What, in your view, what argument did did Mr. Osborne not address allegedly?
Well,
or what ground the trial court could have acted on that Mr. Osborne, the relators did not address?
I don't think he addressed all of what was on page 5 of his reply. And that was, of course, I think there was an inordinate amount of time spent on whether it's 3 weeks, 4 weeks, 5 weeks, or whatever in the briefing. I think the time period is relevant, but that time period has to be looked at in the pattern of what was going on in the case. Now, the state likes to talk about, are we on the eve of trial or something, to try to buy a little bit of time. What we do have in this record is that in July of, let me get to those specific dates so that I don't make an error in the dates. In June of 2021, the state approached us, and there's a lot of talk here about Mr. Slavin being sick. We've not talked on the phone with him for a couple of years, and we hadn't dealt with him personally in a long, long time, like over a year. So the notion that this is triggered by that part of the trial team being sick, we weren't glad he got sick. We're glad he got well. But for his illness to militate in some way to matter in this. But
let me ask you this. Your time has expired. But real quick, can you point out to any particular ground that was before the trial court that they have not addressed in their mandamus?
I think,
and we can look at the mandamus and the grounds urged and
yes,
all that.
I would point the court, since my time is up, to looking at page 5 of Mr. Osborne's response. He gives several criteria there in the conjunctive that have to be together to satisfy or can satisfy as one of the elements that the trial court could use. I suspect he just chose to disbelieve Mr. Slavin, but that's just speculation on my part. Thank you for the court for your time.
Thank you, sir. Mr. Osborne, 5 minutes rebuttal.
Thank you, Your Honor. But let me address just a couple of things very quickly for you related to some of those questions. In Henderson, the trial court refused to disqualify, and the Texas Supreme Court reversed it for an abuse of discretion. Also, just as a factual matter, Mr. Sheets talked about communications with, it was actually Mr. Warren and myself. Those took place after Mr. Austin started to work.
Can you speak up a little bit?
Yes, those took place after Mr. Austin went to work. There were no communications about him going to work between the lawyers at the firms, other than literally just the text that you have. The In re Rubalcaba case is the case that Mr. Sheets wasn't aware of, where the trial court found that case is exactly the one that demonstrates why this case should be reversed for an abuse of discretion. In that case, the plaintiff's attorney filed suit against the defendant. The defendant is the party he had represented as a substantially related matter in an earlier case. The movement moved to disqualify the attorney and his law firm. The trial court found the attorney was disqualified, but not the law firm. In an order just like this one, said attorney's disqualified, law firm not disqualified, no findings of fact, no conclusions of law. On appeal, the appellate court found it was an abuse of discretion not to disqualify the law firm if the attorney was disqualified, and reversed that. And waiver was specifically raised as a reason to uphold the failure to disqualify the law firm. And just like in these circumstances. And what the court said was, if the attorney's disqualified, then the law firm has to also be disqualified. Here, in the testimony, that's not even an issue in this case, because the testimony at trial by the plaintiffs, by Mr. Warren, was they recognized Mr. Austin was disqualified under Rule 109 and could not represent the plaintiffs. And they told the trial judge, we screened him off to prevent him from doing that.
You recall the waiver issue that was raised in that case? Was it waiver by conduct, waiver by passage of time? What the waiver?
It's just a passage of time.
Okay.
And what they said was, if it hasn't been waived as to the attorney, then it hasn't been waived as a law firm. The same thing's true here. If there's no waiver as to Mr. Austin, then there can't be waiver as to Kelly Hart. You can't have a different waiver on the exact same facts. And the plaintiffs have already admitted that Mr. Austin is disqualified. I do want to give you those cases very quickly.
I forgot to turn on the timer, so you're going to end up with a little bit more time.
Okay. In re Thetford is the most recent Texas Supreme Court case, 2019. In that case, the court said that lawyers who violate conflict rules, and they're talking about the same 109 or 106, must be disqualified because of the irrebuttable presumptions. The facts in that case, they decided not to disqualify because they found it was not a substantially related matter. But when they were discussing what would happen had it have been, they said there's no discretion or anything else. These are not really, it is equitable, but we don't turn to equitable things. We're going to stick to the confines of the law, which is looking at Rule 109, and then in waiver, we're going to look at the 5 factors. The other cases that I would point out to you, obviously Henderson versus Floyd, and these are a little older, but sort of in succession, but all in the same vein. NC&B versus Coker out of the Texas Supreme Court. National Medical Enterprises versus Godby, also out of the Texas Supreme Court. And these are just doing variations where you had the rules and in one, for example, the attorney's disqualified, then the rest of the firm must be, for example. And then In re Epic Holdings, a 1998 case.
Those last 3 that you discussed were all from 95 to about 98. Though,
Yes,
right?
the most recent that is really relevant is the Thetford case. And that is a very recent Supreme Court case in this area of disqualification where they said, if you have this kind of a disqualification, the attorney must be disqualified. The reason they didn't find it in that case because they held there was not a substantial relationship with the other matter. Then let me address very quickly, Your Honor, these 5 issues under waiver, because I think if you look at the issues correctly, you'll see why there's no factual disputes. The first one is the length of time between when the conflict became known and when the motion was filed.
You didn't talk about Murrin Brothers. I'm sorry.
I'm sorry?
In re Murrin Brothers. Texas Supreme Court, 2019.
I gotta just tell you honestly, I'm not recalling the facts of that one. I don't believe that it is a 109 disqualification. I could be wrong, but what I think it was, I think it's one of those disqualifications about the improper use of confidential information that's obtained inadvertently. So I don't think those apply. That's the reason I might be wrong about that, though. Don't hold me to that. Okay, so the question is, what's the length of time? It's 3 months and 11 days. There's no factual dispute about that. And the reason is because it can't begin before the actual conflict arose. That's when it first became known. It's not the question of when did a potential for a conflict arise. And that's addressed in the Hendricks versus Barker decision, a 2016 decision out of the Houston Court of Appeals. And they said that there, the potential for a conflict had existed for 3 years, but it didn't actually arise until the suit was filed. And they said, that's when we start the clock. So here it's 3 months and 11 days, no factual dispute about that. In re or construction says 3 months, no waiver. The second issue is what's the party's explanation for the delay? You've got that in our reply briefing. There's a reasonable explanation. If there's a reasonable explanation, there's no delay. The third one is, has significant discovery occurred? The issue is there, not discovery in the entire case, but discovery during this delay period. In this case, there's no factual dispute. During the 3 month and 11-day period, no discovery took place.
And I know you're running out of time. I was trying to save you some time. I think Mr. Sheets, though, was not talking about, and at least just a minute ago, was not talking about waiver from a perspective of the 3 month and 11-day passage of time, but waiver due to conduct by your client in saying, go grab the cash and now I can disqualify the firm.
Okay, if that's the waiver, again, we're on the 4th issue in waiver, and that's, is it a dilatory tactic? No dispute, it wasn't filed near a trial date, not during the summary judgment hearing, not in connection with settlement discussions. Was this communication, does that make it a dilatory tactic? That's the real question. And my answer to that is no, because you have to look at it objectively. And objectively, the warning came before he went to work. So objectively, that's what happened. Warning someone about a conflict cannot give rise to waiver.
Counsel, I'm going to have to cut you off. Your time's expired.
Thank you, Your Honor.
And I appreciate that. The case is submitted, and you are excused to go. We want to thank you for coming up to Lubbock to have the argument. And we also want to thank Texas Tech University School of Law for hosting the 7th Court of Appeals again. We appreciate that opportunity as well. And with that, we will be in recess.